When we're ready?
Yeah, we can pause it if you'd like.
Yeah, let's.
CBRE, and a recognized expert in the practice of family law-based real estate sales across Florida. As a neutral third party, Amanda handles the sale of real property in family law cases. Her job is to ensure the orders by the court are carried out, to see to it that all parties are treated fairly, their interests are protected, to market the property and negotiate between and for the parties so that no penny is left on the table. And when I think about mediation, and our goal to kind of collaborate, that is one of the biggest goals for me as a mediator, is not to leave any gold on the table, as it were. I'm gonna steal one of your quotes here, if I may. We don't want to get involved in people's parenting, but we have a job. We were brought in to sell the house, and sometimes we have to get a little bit more involved than we'd like. We have to cautiously walk that fine line, and that's something that I use as a metaphor too when I'm talking about mediation, and often find myself walking what I call the mediator's tightrope. And so I see the skill that we use in our different jobs actually kind of running parallel to each other as a neutral third party, and somebody who's constantly walking, you're just flirting with the edge there, as it were. And so we are excited to learn from you. And without further ado, Amanda.
Thank you, Josh. That was great. Thank you very much. Very kind introduction. So, as Josh said, I'm Amanda Reichert. I'm a certified divorce real estate expert, and I'm excited to be sharing a couple of hours with you this afternoon to just take you through what some of my experiences have been working in the divorce field, selling real estate as a neutral. So, I'd like to keep this open and collaborative. So as we're going through this today, if something pops in your mind or, just, if you have questions, feel free to ask me as we go through. I'd like to just keep it informal and keep it really just a casual, just an education experience, but also to make it so that you really get what, something out of it as well. Let's see here.
And if I get any questions on the chat, then I'll just let you know.
Feel free. Yep.
Okay.
Any questions that come through the chat, definitely. And I had a couple of questions that were asked ahead of time, and I've got them bookmarked in my presentation, so I'll make sure to address those as well as we go through. So we do have an agenda today. Josh covered a little bit on the about me. We're going to cover when reality hits, the state of the market, to sell or not to sell, married to the mortgage, divorce, probate, and civil, so real estate matters surrounding those, point in time valuations, equity and proceeds distribution, timing of orders, agreements, case studies, and best practices. And then I'll just get into, just to wrap things up, what is a CDRE, and any Q&A that comes up that isn't addressed as we go through. So just a little bit about me. Josh went through the, just kind of my bio, so I don't want to spend a lot of time on that. And it is in your packet. I'll just jump right into when reality hits. So as people are going through the divorce process, it is oftentimes the very first time in their life that they have ever been served with something. And it's incredibly scary, whether they've been actually served physically by a sheriff that has come, or a process server to their job, their employment, their home, handed them documents, they open them up and they were like, wait a minute, my spouse wants to divorce me. It might be the very first time that they ever hear that. And so they go into fight or flight mode. So it can be a very, very frightening time for them. Because it could be the very first time that they've ever had any experience with the legal process. They open their documents, they have no idea what they need, they don't know what they're looking for. And usually the very first thing they do is, well, I need to lawyer up. Well, we know, where you all are mediators, that mediation is an incredibly effective way to be able to work through that process of untangling the knot, unringing the bell, to help them to get on with their life in a kinder, gentler way, so that they haven't exposed their finances to thousands upon thousands of dollars in legal fees. And sometimes they have to, but in mediation, it's one of the goals, certainly, is to be able to give a kinder, gentler divorce. Which leads me to the next point, the financial. So the division of assets and the liabilities, and surprises often abound within that. And once people start uncovering maybe things that have happened, and infidelity, or gambling, or drug problems or addictions, it can be very hurtful, and again, very scary, because the person on the other side is looking at possibly bank accounts that have been completely depleted, and credit cards that have been taken out in their names, and they've been run up, and you name it. It's just so many things can have happened. The same goes with real estate. So very frequently, home equity lines of credit. There's a debit card that goes with the HELOC, and I'll use HELOC, but that stands for home equity line of credit. There's a debit card that people carry around for their HELOC, and oftentimes maybe one of the parties doesn't even know that it exists, or they took it out a long time ago. They may have never used it and they forgot about it. And then all of a sudden, they get to the table and they start looking at the finances for the home. And it's discovered that this home equity line of credit has been completely depleted. And it might be 50 or 90 or $200,000 in equity that is completely gone, that otherwise would have been used for them to get on with their lives post-divorce. And then there's the stress and the emotional toll as well. So, and I'm going to go into this in just a minute here. The Holmes Rahe stress inventory. And is anyone here familiar with that stress inventory report? Have you ever seen it, heard it, used it? Okay. It is something that I can send out the link to it afterwards, and you can go in, you can actually just kind of run one for yourself. And if you look at the points, okay, the points are on the left side of the slide that I provided to you, okay? Divorce is the highest stressor in terms of points at 73 points. Followed by separation from mate, 65 points, job loss, 47 points, change in finances, and so on, okay? So on the left, those are all points that could potentially be contributing to the amount of stress that one person's experiencing over the course of the divorce. And anything over 300 points is really kind of very hard for people, because it puts them in a place where they are really either having a breakdown or on the fringe of having a breakdown. Okay, so you've got 150 points or less, 150 to 300, and then 300 points or more. Well, if you go by the previous screen, okay, and I've got this on this slide as well, where you've got all the different points that you have. Those come to over 300 points, and that's just a matter of divorce. And all of these items can be contributing factors to a divorce. You have, job loss, change in finances, change in spousal disagreements, taking on a new mortgage and a new home, foreclosure, and major changes to living conditions. So it's really important that as we go through this process and we're working with our clients, to keep that in mind, that they're really experiencing a tremendous amount of stress that otherwise may not contribute to them lashing out or being angry or swearing or whatever it is, being obstinate and disagreeable because they're worried about where their future is going to go. Okay, so when reality hits, there are 4 primary sectors to the intersection of divorce. You've got family law, real property, financial, tax planning, and mortgage planning. And for purposes of today, under family law, it's gonna be mediation. Mediation falls under that because you all are essentially acting in the capacity to mediate their divorces, write their agreements in some or many instances. How many attorneys do we have on the call?
Y'all wanna raise your hands in the chat? I think there's at least 5 or 6.
Okay, that's
that
okay. I don't need an
can
exact number. So as mediators, non-attorney mediators, you may or may not be writing the agreements. The attorneys probably are writing the agreements. And so you've got, you're falling kind of under that family law category. So you've got those 4 different categories.
Amanda, so we do a lot of pro se as well, where we do write the.
Where you write the agreements.
Oh, yeah.
Okay,
And even with attorney cases, a lot of times in our court program for family, I know our contractors, family contractors and family staff, we write agreements all the time.
okay. And that's my experience is it can go both ways. Where you have a mediator that is a non-attorney that writes it, notarizes it and files it. Or they may send it to an attorney to review, depending on whether the client wants an attorney to review it before they actually finalize it. Or the attorneys may be doing it. So lots of different ways there. There's no right or wrong way. It's just whatever works for the parties. Here, so what happens to the house when, what happens to the house? Sorry, bear with me 1 second. When parties, I'm sorry, I just drew a blank, so. What happens to the house? There are a couple of options. There's a buyout option. There's a sell now or sell later option. Or there is the option to continue to own it together. One party makes the payments, the other party moves out. And then at some point in time, it's been mediated or agreed to that the house will either be sold or a party will buy it out in say 2 years, 3 years, 4 years. Right now is kind of a great example of when that could be happening more because interest rates have been so high and people have purchased together at lower rates. And it's difficult for them to be able to afford to keep the same house when interest rates are 3 or 4 points higher than they were when they purchased it initially. So. Maybe these are, oh, there we go. I'm sorry, my page was out of order and it was just kind of, so the state of the market, okay, and I only pulled numbers for a very small demographic of real estate. I pulled it for Sarasota, Bradenton, and Lakewood Range. Okay, and I'm also going to give you numbers for last year for all of Manatee County, but in those 3 cities, okay, the number of active listings for the number of active listings are 354. The number of pending listings, which means that they are in contract, is 92. And then the number of sold homes in the past 90 days is 210. This is the first time that we really, in the last 4 years since COVID, have seen the number of active homes higher than the number of pending or sold homes. And that's a good thing in some respect because it means that we have a more stabilized market. But it's also not a good thing because people that are trying to sell their homes are not selling as fast and they aren't selling for anywhere near as much as they were for a number of reasons. So the median list price in those 3 cities, okay, as of 2 days ago was $525,000. The median sold price is $451,000. Okay, so there's a very big disparity between what is the homes are being listed for and what they actually are closing for. 1 year ago, and I have the Manatee County number for this because I pulled it off of another presentation that I have. 1 year ago, that number was 663,000 and the sale price was 425,000. So it's kind of like makes you scratch your head thinking, how could the sale price possibly be lower than the current day sale price of 451 when the list price was 663? But the reality is that people just did not have their heads wrapped around a changing and shifting market. So now you've got people who have become more realistic and realtors also who have become more realistic, or they're just doing price drops, because the houses are sitting and they aren't selling, okay? And there's still lots of new construction that is going on. And what has occurred with new construction is you have builders that have no qualms with dropping the price to get their homes sold. And then they're also offering massive incentives on both interest rate buy downs, also with just closing cost credits. So on a regular basis, I see closing cost credits in sold comments of around $25,000 to $70,000, depending on the community, depending on the price of the home. So you're talking about a lot that's really kind of going on that unless you're really in it every day and tracking it, you just don't see it. But it is something that you as mediators really need to be very cognizant of when you are working through the negotiations for the house. There are a couple of reasons why I say this, okay? One is, excuse me, if you're negotiating someone stay in the home for 2 years, this may go down farther. And in 2 years' time, there may be less equity than there is today. So if you negotiated an agreement based on what's happening today, it could be less than 2 years. And the party that's supposed to buy them out the agreement may be completely obsolete. May not even be, they may not qualify to even be able to buy the other person out. Interest rates could go back, like, I don't think that's gonna happen, but interest rates could go up. There's a lot of dynamics that go into this. I think we're kind of in more of a market that is beginning to stabilize. And unless something completely insane happens, in this world, I think we're gonna see things kind of stabilize for the next couple of years. I think that the prices are gonna continue to come down. I think that we're gonna see them get closer to, pre-COVID prices. But it's something just to keep in mind as you're negotiating and as you're working through buyouts and agreements and where you're negotiating assets, because one asset does not equal the same value as another asset. It's really important. The house can change in a moment, as you saw in COVID. So the next question is to sell or not to sell. And once we open the can on that and start asking that question, it kind of starts making people think a little bit more about, well, what do we do? Do we sell it? Do we not sell it? What is the equity look like? Do we have marital debts? Do we have equity in excess to cover those marital debts? So the questionnaire too is, how is a realtor brought in? And there are a couple of different ways that happens. Sometimes it's selected by the parties. Sometimes a recommendation is made by the mediator or an attorney. And I provide expert testimony and unbiased neutral valuations. So sometimes the court order, if I have to go in and testify to a value, the judges will write me into the orders so that, because I've been identified as the expert, and the judges will put me into the orders to list and sell the home.
I have a question.
Sure.
So a lot of times when we're negotiating, people are like, well, on Zillow, it says this, and on Realtor.com, it says this. How accurate are those evaluations?
So that is a fantastic question, and the answer is if you are looking in a community where everything has been built within the last 2 or 3 years, and every house is basically kind of identical, especially if the builder didn't permit customization, like for custom homes, it's pretty easy. And Zillow, this estimate, it might be pretty accurate for the space for the home. But once you walk into the home, that's where the difference takes place. So, you may walk in and, people may have smoked cigars or cigarettes or marijuana in the house. They may have pet odors. They may have just filthy, disgusting living conditions or hoarder situations. And that's where the difference really comes in, because what Zillow is doing is it's taking every house in whatever their algorithm is, and they're throwing all of those homes into a bucket, and they're spitting out numbers based on what has sold. Okay, where this gets a little bit dicey, and I'm gonna go through a market valuation of a home that was damaged in Debbie. Where things get dicey with that is homes that are older, and people have made major renovations to them, and you've had damage to them and stuff like that. So I won't get too deep into that just yet, because I am gonna cover it. But the answer is, it could be sort of okay, but the best way to get a true value is to either have an appraisal or have someone like myself come in and perform a market valuation on the house. So next we're gonna go on to the mortgage. And when people are married, they're not just, and they own a home together, they are not just married to one another, they're also married to their lender. Because that house is owned by both of them in many cases. In Florida, we do have homestead protections. So even if someone is married and one spouse is not on the title, it still makes them an untitled spouse. They still have homestead protections under the Florida law. And the house may have been purchased before the marriage. It may have been purchased during the marriage. For some reason, they may be on the title. They may have debts or liens that they didn't necessarily want to be on there because of attachment for various reasons. So there are a lot of variables that go to that. But with the mortgage, if you're on the mortgage, you're on the mortgage. Okay, so what I'm going to do is just go through some of the various terms that are used within the mortgage world that I'm sure you all are hearing on a regular basis, just to provide some clarity to you about what does this mean and what direction can I take to help my clients to get to the desired outcome. Okay. So one of those words is a buyout, and that essentially is when one spouse buys the other's share of the home, and they become the sole owner. Okay, they are only on title and they are only on mortgage. Okay, the other person goes off of both of those. If they were ever on both, they may have only been on one or the other, they may have never been on either. Okay. And this often requires refinancing to remove the other spouse from the mortgage. So then that leads us to the word refinance. So refinance is when the mortgage is paid off and replaced with a new one, brand new, okay? And it is in the name of the spouse keeping the home, and refinancing can be a beneficial interest if rates have decreased and required to remove one person from financial responsibility. Then there's a cash out refinance. Okay, so assuming that there's equity, and one spouse needs to buy the other spouse out, that's where a cash out refinance would come in. But there has to be equity, and the lender only loans on around 80% of the equity value. So if you have $100,000 in equity, and the plan is to split that equity 50,000, but you can only get a buyout for 40,000. Okay. These are just things that just, you don't really think about, okay? But they're really important to factor into that process, because where's the other $10,000 gonna come from? Is it gonna come from stocks? Is it gonna come from private loan? Is it gonna come from negotiations? Like, they're just so, it kind of opens up more questions. Because they're not gonna be able to get the full $80,000, or the full $100,000 rather, I apologize, the full $100,000 in that particular case. So cash out versus home equity line of credit. So with a cash out refinance, the current mortgage is paid off and a new one is entered into, and new rates and new terms would apply. So if say for example, someone has been paying into a mortgage for 10 years on a 30-year loan, they refinance, they would they would be in a brand new loan. A cash out refinance would be a brand new loan. So they may have to go in and it would be a 30-year or 15-year loan, whatever they ended up selecting. So it is going to be a brand new loan with new rates. And then a home equity line is a second mortgage in addition to the first mortgage. So a cash out refinance or a home equity line of credit could be used in addition to just a refinance if someone needed to be bought out, if they have the financial standing to be able to add that second loan. So in the previous example where I gave, where the loan to value is 80% and you have 100,000 in equity and you've got to make up that $10,000, a home equity line of credit is a place where that could happen. If the spouse who wants to keep the home and buy the other out is not, there's just not enough equity built into the refinance to be able to make that happen. I know that's confusing. Does that make sense to everyone? Okay. Okay. It's very confusing. That's why I have it all written down. And that is why I really encourage you to have a certified divorce lending professional. The acronym is CDLP on speed dial, so that if you were sitting with a client and if their questions like this come up, you can literally pick up the phone and talk to them, and they can give you specifics about the loan values and loan to value ratios and cash out refinance rates and stuff like that. Okay. So I have been asked a lot lately about assuming mortgages. And while this is not my lane, it's something that comes up all the time. So I want to just cover it today. And I think that it would probably make sense at some point to have the CDLP come in and give you a presentation about the divorce lending process as well. Because 2 + 2 in divorce doesn't equal 4. And a CDLP has ways to get very creative with the financing to make it so that things either really are able to work, or they know before people get too far down the line that it just won't work. So assumption of a mortgage, it is my experience that, I'm sorry, I'm kind of behind on the slides here. So it's my experience that assumptions of mortgages are only able to be done with federally backed loans. So a VA, a veteran's loan, or a government loan, an FHA loan or USDA loan, okay? Conventional loans, historically, to my knowledge and my experience, are not assumable. So when you're sitting down with someone and one party says, well, I want to assume the loan, I want to assume the mortgage for the house. Maybe they don't have equity. They might have negative equity in the house. And there's not going to be a cash out refinance. There's not going to be anything like that where cash is transferred from one homeowner to the other, because there may not be money there to even make that happen. But one person wants to keep the house. It might be in a phenomenal school district. Their parents might live next door. There are lots of variables for that. And it's just something that I want to make you aware of. When you hear that, There are two types of loans that can be refinanced, unless it's specifically written into their note that an assumption is the bank will assume an assumption, okay? So that's gonna require some homework for them to do, is to go into their note, look, or make a phone call to the bank to find out if their loan is assumable. Okay,
Do you want questions now or later?
you can answer, you can ask questions now.
Okay, so if anybody has any questions, please put them in the chat
Yeah.
as well, and, or raise your hand.
Absolutely.
One question I did have about the, status of being married versus unmarried at the time of the refinance. Does it make a difference one way or the other? If, you're currently married, but you want to go ahead and address the whole house situation, whether it's a refinance, as a married couple, or after the final judgment, when you're no longer technically legally married, but you still haven't.
So I am going to cover more of that in the title section. Because there is timing matters in
Right.
divorce. For a lot of reasons, and I'll get into that.
Okay.
But as far as, beginning the process of doing that, sooner is always better than later.
Okay.
And they can set a date for when they want to have that finalized with whoever their lender is. So if, they say, well, we're expecting our divorce to be finalized on this date or that date, if they can work towards doing that and then having that happen. With a refinance, there is also a 3-day right of rescission. So you may want to think about that and just factor that in as well. Okay. Let's see, so there is one exception that I'd like to talk about. And I don't want to get too much into the weeds because like I said, loans are not my primary area of expertise. But the question has been coming up so much that I wanted to just put it out there so that you at least have some idea of what is available, okay? If someone wants to assume the loan, there is, like I said, there is an exception. And it's called the Garn Saint Germain Depository Institutions Act of 1982. Okay, there is a handout for each of you. Okay, that gives you a little bit more detail on what that is. All right, and then I have a CDLP that I work with a lot. And I asked him just to give me some clarity about what this means. And I'm gonna just read his email response to me so that you at least have kind of an idea of what that workflow looks like. Okay, so it says, typically a divorce decree would state that, and we're using husband and wife in this particular case, with W and H. So typically a divorce decree would state that the wife would be responsible for loan payment going forward, and husband would be held harmless if there was a default. This is a legal assumption, but it has no relevance when it comes to the creditor's ability to go after both husband and wife if a default would occur. So what he's saying is that under the Saint Germain Act, there is a way to write it into the agreement that wife is assuming the financial responsibility for the loan, okay? And husband is off the hook from it. He is not responsible for paying it, okay? That's fantastic in legal terms, but in practicality, the lender still has husband on the hook for the loan, okay, if wife defaults. So the MSA is used to show that the husband is no longer responsible for repaying the loan, so that debt payment can be excluded from his debt ratio when seeking other mortgage financing. So that is where the benefit to him comes in with using something like this, because what it does is it gives wife ability to stay in the house, be the sole responsible person for the mortgage, okay, without having to refinance, without having to change the terms, without interest rates going up, without having to start at zero again if they're 15 years into a 30-year mortgage. So this gives wife some stability with that. Okay, it still does not take husband off the hook, but I'll continue. So late or defaulted payments would still appear on both husband and wife credit reports. So the only thing so far that this is doing is it's freeing up the debt that's associated with that house from the husband's liabilities. So that if he needs that credit space, that he's got that to be able to go and buy another house, or if his car dies, he needs to purchase a car. He's got credit that's freed up, because it's not legally tied to this mortgage. Does that make sense? Okay. So the wife can seek to assume the loan by filing for a qualified assumption with the loan servicer. She has to qualify for the assumption to be approved. Okay, so in other words, they have to go through the same underwriting review to be approved for the assumption. And this is the only assumption that completely takes the departing borrower off the hook regarding the repayment of the debt from a legal and credit reporting perspective. The loan servicer is not required to grant an assumption with the current loan terms. An approved assumption depends on the financial strength of the borrower and loan servicer policy. This type of assumption takes the prior borrower, the husband, off the credit hook. And maintenance and child support payments have to be received for at least 6 months for them to be considered as qualifying income for the party assuming the loan, if that income stream is needed to qualify. The 6 months depends on whether it's a conventional loan or a government loan. Some loans, like conventional loans, it's 3 months. For FHA and VA, I believe it's 6 months. Okay, but again, that's an area for the lender to ask specific questions on when you're working through that process. Let's see, where was I? Complications can occur if the assuming borrower was not on the financing previously or not on title previously. So if you have a one-titled spouse and that spouse wants to assume through the Garden St. Germain Act, it could provide for some complications, but again, it's something that may or may not be done. I don't want to get into the weeds too far on that. This is where the legal process of divorce does not match up well with mortgage finance underwriting requirements. So on paper, it's easy to do anything we want to do, right? But in reality, you've got the lending institution and it's their money, and they have the ultimate final say over what they do and what they agree to do and what they agree to accept as risk. So it's always a great idea to make sure that it can be done before you put it into an agreement.
Sure. It goes to my next question then. So if you are to be retained, is there like a release of information or something that we would sign to basically allow you to be, I'm saying if I'm a client, like I'm a divorcee, is there something client litigants would sign to allow you to be able to talk to their lender and to be able to, you know, have these conversations on our behalf? Because I know sometimes they won't speak, you know, with anybody except for the person who's the name.
So the answer is yes. That most common, okay, and I'm not even touching on short sales or foreclosure avoidance today. That is a most common occurrence if you have a short sale circumstance where there would be a stack of financial paperwork and releases and other type of disclosure and documents that we would need the parties to fully cooperate in disclosure, signing everything. And that would give myself, and I have a team for short sales and foreclosure avoidance to be able to talk to the lender on their behalf. So the answer is yes, but under normal circumstances, as a realtor, I'm just not going to get involved in that. It's something that they would work through the loan servicer to make happen. And they may have to call 15 times, and I know this sounds crazy, they may have to call 15 times to get the right answer. So if they call once, they may get somebody that has no idea that the St. Germain Act even exists. And they'll say, nope, you are not qualified for a refinance. under this act, I don't even know what this is, blah, blah, blah. They may have to call over and over, or they may have to escalate it to be able to get someone who actually knows what it is at the loan servicing institution. Okay, so again, just building in some time, and the money for the house should always be one of the very first things that's negotiated. Especially if one person wants to keep it, because there are lots and lots of layers of things that can be uncovered as you're going through that process, that you don't want to wait until the end to find out you've spent 50 hours mediating and thousands of dollars in whatever else it is, to discover that you just can't make the assumption work. Or if the assumption is agreed to and it's put in an MSA and filed, you can't go back from that unless you have parties that are willing to agree to it. So it gets very, very complicated with kind of putting the cart before the horse. And the house is one of those matters that's very important, that the sooner you start incorporating that and working through the numbers side of it, if one party wants to keep it, the better off everyone is going to be, the further down the line you get. Okay. So I'm just going to continue reading where, with his explanation. So this is where the legal process of divorce does not match up well with mortgage financing underwriting requirements. Most MSAs will require that the person keeping the home refinances the loan within a certain period of time without a review of their capacity to do so. This can leave both parties in limbo for a while, especially when market interest rates are higher than the rate the borrowers currently have. The itemization of mortgage interest typically becomes more favorable for a single person, so some of the refinance interest rate shock from a refinance is covered by an increase in federal income tax reductions for the borrower retaining the home. So I know that's a lot of information to digest, but like I said, it is something that I wanted to just put out there so that as you're mediating, it's just, if the light bulb goes on and you go, wait a minute, we probably should hit the pause button here. And, you know, wife, husband, let's get a CDLP involved so that we can make sure that you are even qualified, or we can find out what it's going to take for you to be qualified. It might mean a little more of this and a little less of this. It might mean debt being paid off. There's just, you know, it helps you to be able to negotiate a better agreement in the end for both of the parties when you have everything in visible format. Okay. Let's see here. Okay, so I've covered quite a few things on this particular slide. So anticipation is key. Anticipation for prevention is key. So I talked about seeking a qualified CDLP, getting a full tri-merge credit, not just a free credit report, because that is not, it's kind of like a Zillow for credit. When you go on free credit report, you want someone who is, it's in an institution of banking, finance, that is pulling your credit report from the major credit bureaus so that you actually get a true picture of what that credit looks like when you're looking at refinancing or qualifying to do so. Get a preliminary title search for second mortgages, delinquencies, taxes, judgments, foreclosures, and any additional ownership interests. Like I said in the very beginning, there have been so many times that, because we had a crash, we had a real estate crash in 2007, 8, 9, kind of went into 10, and people did loan modifications. So, and they might still be in the house that they bought in, you know, whatever that period was. They did a loan modification and they have no recollection of it. So one of the questions that I always ask people when as part of an intake is, did you ever perform, if they own the house, or even, you know, even now, it's any period, right? Have you, COVID, for example, people put their homes into forbearance. there are fees and other things that could have been backloaded. I think there were some people that were able to put their homes in forbearance for 18 months. That's a long time to go without paying a mortgage, and if there were additional fees and interest and taxes and HOA fees that were tacked onto the back of that, that the mortgage company paid on their behalf, you could be talking about 30, 40, 50,000 dollars of money that they're not seeing on their statement, right? And they may go to sell the house, they think they have $100,000 in equity, and they may not even have enough money in equity to close out the transaction. It may actually be a short sale. So it is very, very important, especially if you have a case where there have been shenanigans. Okay, and I'll leave it at that. It's so important, but also too, to ask the question, have you put the house in forbearance? Was there a mortgage modification? Because you're not gonna want just the statement that they're getting in the mail. You're going to want to be working from a payoff. They can call the bank, they can order a payoff. It's a payoff per diem, so payoff per day through, say, today's the 31st. They might want to pay off per diem through February 28th. If they know that that's gonna be kind of like what their final, their final MSA is gonna be, and things are gonna be wrapped up. And that will give everyone a good idea of what the payoff of the mortgage is, because it's gonna incorporate fees, interest, HOAs, taxes. It's gonna incorporate all of that stuff into what that payoff is. Okay, so you again have really good numbers to work from when you're negotiating what the final distribution of funds is or what have you, okay? And that is it for that slide. So we're gonna talk a little bit about civil court and other real estate matters, okay? So in family court, you've got parties who have children and they are married generally, okay? Where minor children are involved. And then there's a formal process for the progression through the court with the intermittent progress of hearings. With mediation, hopefully you're able to mediate and you don't have to go through the courts, okay? You may find that the mediation doesn't work and they end up in litigation. So in that particular case, they would be going through the family court system. Civil, they're not married and there are no minor children involved. And if the unmarried parties share minor children, the case, from my experience, every single time it has gone to family. Even if they're not married, okay, it's a civil union, they're not married, but if they're minor children, they put it in the family courts because the family courts are more equipped and they just are better at working with families to be able to get them through that process than the civil courts are, okay? And then civil court can take years to get through. There are no formal hearings and progress hearings and all of that stuff. And I still am a #1 advocate of mediation. Like, I think that you get better outcomes and the process goes faster, smoother. It's less traumatic for the people, for the children, for the finances, emotionally and so forth. So I think the litigation should be used. It certainly has its place, but as a last resort, in family matters. So next we're gonna go into the value of the house. I just want to check on my time here. So next we're gonna go into the value of the house, okay? And each of you, let me just see here. So we're gonna talk about the value of the house, and the #1 thing that I'm gonna recommend is that you utilize credible sources to establish what the value is, okay? Realtor.com is not gonna be a credible source. And I would say that as a general rule, a realtor, a real estate agent, or friend or family member of the family of the divorcing couple, they are not going to be reliable because they do not understand what truly is, number one, at stake, and how to really go through the process of documenting the condition of the house. Okay, that is especially important if one person wants to keep the house, or if you have unrealistic expectations about what the house is worth, and you're using unrealistic numbers to establish settlement figures, right? You've got to have really solid numbers to work from to be able to get through that. Okay, so what I want to do is I have, each of you has a handout. It's like a little bit of a little grid here. Okay, I'm gonna open this particular, you'll just bear with me 1 second. I'm gonna open a market valuation that I did.
So Amanda, for all of our folks online, can we direct them to the material?
I'm opening it.
I sent it,
I'm opening.
I sent it to everyone.
Okay. As well, yeah, I just wanted to direct them to it.
Okay.
So they will not have a copy of this.
Oh, okay.
They will not have a copy of this.
Then I
And
didn't
if you
send
don't
it.
mind, I'm gonna sit just because I'm gonna go through it, okay? But this is a market valuation that I do. This is what the attorneys and the couple gets. So you can see it's very extensive. This is not something that I go into the multiple listing service, hit a few buttons, and magically numbers just appear, okay? That is not what I do. The importance of this document is so critical for establishing value, like a true value of the house. I have 2 different realtors, couples. The husband and wife have both been in the business. And I have been called in to perform valuations because they cannot agree on a value. And they're realtors, okay? One of them, the one that I'm gonna be going through, is the house was damaged so severely with Tropical Storm Debbie. There was 4 feet of raw sewage that came up on the inside of the house to the light switches. On the outside, the water was to the soffits. So on the exterior of the house. So it is really important that you have a realtor that not only just, really gets condition being part of a value or a deduction of value, okay? Damages and so forth. This is not the one we're going to be going through. This particular case, and as you can see, it's hundreds and hundreds of pages. This particular case has around $250,000 in damage from Ian. And wife wants to keep the house. She's got a little girl. She just wants to keep the house, and husband thinks the house is worth $750,000. She has $250-ish thousand in repair costs, insurance claims that have been denied, public adjuster report that has all of these things outlined in it, okay? And realtor reports that are all over the place. And so I was called in to perform a market valuation to testify to the value with all of the damage. Okay, so I'm just gonna kind of go through this and I'm gonna do it fairly quickly, but I just want to make sure everybody can see the report. Okay. So this was the front of the house. I pulled up to perform the market valuation. And you can see the garbage and the trash that was just literally piled up on the outside of the house, okay? And then I go in and, I've got a whole disclosure. When I go into people's homes, I am not judging them for how they live. I'm not disparaging them for the condition of the way that they live. I'm there to view the house and the structure of the home and to provide an analysis of that to give them a value of the house. When they move out, they're taking their junk with them. Okay, so it's not a disparagement, but sometimes if they are planning to sell the house, I have to incorporate that, like the condition and listing recommendations into my report. This particular one is not a sale, but I will have to incorporate listing recommendations in where I get into extensive detail about, you know, the disgusting condition of the house and what they need to do to prepare it to get the most money out of the house so that there's not waste. And that one of the spouses is not injured as a result of the way that the other spouses lived in the home or cared for it, or, you know, just the depreciated value.
I
Okay.
mean, especially with all of the hurricane damage and everything, I had a mediation not too long that this became a big issue. It was, and the house wasn't really all that valuable, you know, I mean, it was, you know, not like this, it was probably $100,000 worth, anyway, before the hurricane. But then the hurricane came, caused so much damage that they had done, an extensive amount of repair work, but it got to the point where coming out of pocket to do additional repair work because FEMA was gonna come in and just basically level it and start over again. But there was something that was said in the mediation about how FEMA to rebuild, somebody has to stay in the house for 3 years. Like they can't live it in the 3-year period that they would have to, if FEMA came in and rebuilt for these people, some grant, that they have to stay there for 3 years. Well, they didn't want to stay there for 3 years. They wanted to get divorced and sell the house and split the proceeds. But where do you find that balance of, you know, fixing the house up to get more out of it before you get to a point where you're really not, you're taking your liquid money, putting it towards a house where you're really not gonna get that much out of it versus what you put into it. It's kind of like how they say building a pool, you know, it's gonna cost you a lot more than it's gonna give you back. Solar panels, same thing, it's gonna cost you a lot more than you're gonna get back.
That is a very complicated question, okay? And ultimately, it really comes down to a couple of things. How much extra money is there? Okay, like, you know, first question, are your mortgage payments current? Are your taxes being paid? Is your HOA current? Because those are all foreclosable items, okay? If they are not current, we need to be looking at something else. Because if you can't even afford to make the mortgage payment or your HOA payments, where is $20,000 or $30,000 going to come in to cut drywall out, rip it out, rip tile, carpet out, baseboards out, and then go in and either, you know, sell it like that. And I'll give you some examples in this market evaluation of that, okay? Or you bring the house back to the condition that it was or better prior to the damage occurring. And that can be hurricane damage. It can be just deterioration. I mean, you know, it's like so often divorces can take years. And if you have one person in the house that can't keep up with the yard, they can't keep up with the pool pump breaks. And then all of a sudden you've got, you know, a green pool that has frogs and other stuff living in it. And, you know, you've got the yard that, you know, is now literally littered with weeds and everything is overgrown. The answer is it depends. It depends on the house, it depends on the finances, it depends on the motivation of the party that's in the house. So there are just a lot of moving targets when it comes to the house. And there's not one size fits all answer for any of that.
If a third party like FEMA is offering money to restore the home with the caveat that they have to live in the home, does that mean that they just have to retain ownership for that period of time? Could they like rent it to other people?
So the answer is I am not sure. I don't know what the FEMA regulations are. That's an area that I just have not got involved in. So I can't answer that for you. I
Okay, I was
don't
just
wanna
curious
give you a
if-
Yeah, it
nonsense
just came up
answer.
in a mediation. I'd never heard anything.
But it certainly is great. I will, now that I've heard it, go and I will research it so that I have it for things like this going forward. But the answer is,
Yeah,
I don't know what the answer to that is.
Because I can imagine they're dealing with the same thing in California and,
Right.
just any places of total devastation. But that really put these folks in a pretty bad situation because they were both elderly on top of it all. And, one of them needed to move into a nursing facility.
Mhm.
So it put everything on her. She either had to, get it to a point where they could make some money off of it, by improvements to sell as is, but it couldn't have been the as is as it was, because then it literally needed to be leveled. But then again, she couldn't stay there for 3 years because she couldn't afford it without him. And it was a circular situation that I just felt terrible for these people.
Yeah, and there are so many variables there's just so many variables to fix it or not to fix it.
Right.
There just is, people have owned their house for 30 years, they don't have a mortgage on it. And they have, $500,000 in equity. Maybe it makes sense to fix it, and maybe it makes sense to just take $100,000 or $150,000 off the price of the house, and you sell it to somebody that comes in, is gonna gut it, flip it, and you get out of it. And I think that age and capability and finances,
Right.
all of those are factors that come into play with that. I mean, I'm dealing with that right now with a house that's got a lot of acreage. It's a very large house. One of the spouses has been out for quite a while. The other spouse is living in the house and has had a stroke. And is in, late 60s, early 70s. So, and the house has so much stuff in it. And there's a lot to be done. There's hurricane damage, there's screens that are missing, there's, there's a pole barn where the rollers were ripped off of it. So the answer is, it just depends, and ultimately, I think that it's a conversation that happens with you as the mediator and them as the client to really come up with a plan that they both can live with.
In a family mediation context, I'm thinking too, as well, and I'm sorry, and to interrupt you, is sometimes, the issues of support might need to be addressed first before you can really get into those, especially if there's alimony, because like you said, there needs to be, for it to be factored into the credit income ratio. You're looking at a good 6 months or 3 months before, it will be accounted for, and, so you might have to address some of those financial support issues first.
Absolutely.
Sorry, Ann, go ahead.
Well, no, I was just gonna say, I think it depends too on what stage of life you're in. I know of a situation where a couple just got divorced, there was some storm damage and things like that. 2 children. They're not, either one of them gonna be able to buy a house at this point. They're in rentals, so the assumption that people are gonna take the money and thrive is wonderful, but sometimes people are so set back by all that's going on externally with storms, divorce, 2 children to raise. Their options are very few, yeah.
Limited, and, one of the things that people don't really even talk about is credit.
Yes.
Because so often the credit of these people that we're working with is just decimated through this process, because you're going from 1 or 2 incomes in one home to 1 or 2 incomes for 2 homes.
Yes,
And that may not be enough. And then, if you still have the child care and the car payment, just all of the living expenses. And then you throw damage in, and you throw all of these other factors, right? Like truth is stranger than fiction.
well, in this case, grandparents are co-signing the rentals, and this isn't because these people are not working and have good jobs, it's just the way it's all
Yeah, I'm
descended
seeing
on
it
them.
so much where
Yeah.
we're, there's just, we live in an area where there's a lot of wealth in Sarasota. And in, Sarasota and Manatee County, there's a lot of wealth here, but there also are the working poor. And they're not exempt from divorce and all of the factors that go into that. And, if they have children, like, it's just, you deal with it, you work with it every single day. But yes, it's, if they have a house, that is probably the largest asset that they have. And the equity from that may be depleted. There's just a lot of factors, and it's really, it comes down to working through what their end goal is and helping them to get there. Okay, so I'm gonna get back to the market valuation. There's a lot of mumbo jumbo here. There's a lot of stuff about what I use to get, are you seeing this in full screen? I hope so. Okay, all right. So, I pulled title. In this particular case, there was no lien on the title, except normal things like more, in this case, one mortgage. But there were no list pendants. There was nothing that indicates that the mortgage hasn't been paid. There are no HOA liens, there are no tax liens, municipal liens, any of those things. That would throw up red flags for me that I would say, okay, we need to probably dig a little deeper into this. Okay. So then I go into the condition assessment, and as I mentioned, it's not unusual for otherwise beautiful, well-maintained homes to fall into excessive disrepair as parties are navigating the extremely stressful and very costly process of a litigated divorce. It may not even be litigated, it's just mediated, right? I talked about how they're going from one home to two homes, one income to two incomes in some cases. It's just a lot. And, if the refrigerator goes, or the pool pump goes, or the sprinklers stop working, there are just so many factors that go into that. And keeping up with the house is just one of the things that people just don't care about. And then if you throw salt on it, that wound, if they live in an HOA, they may be collecting fines if their lawn looks like, like cooties too. If they can no longer afford lawn service, if they can't afford, the spraying to come in for lawn pests and stuff. So you may have HOA fines just tackled on top of it. There's things there that, again, what I'm saying is the more that you know and the more you can be looking at the whole picture, the better the outcome is going to be, because you're just going to know what you're dealing with in terms of navigating to the end result. Okay. And the house is a big one in that. Oops, let's see here. So, okay, so these are just condition assessments. So this is the front exterior. I mentioned that there's a lot of garbage there. It's in a very nice community, and but it experienced unprecedented flooding in June from Tropical Storm Debbie. And many of the homes that are in the subdivision still have dumpsters and trailers and storage things like pods and eye boxes and all of that are still sitting in the driveways. And it has been, that happened in June, so 7 months time. In this particular case, this home was not in a flood zone, so he filed a claim through insurance, and it was denied because he didn't have flood insurance, and this was a flood event. So, they had to deal with all of that in cash out of pocket. Okay. And there's a lot of other stuff in here. This is the back of the house. They added the pool 2.5 years ago. Outdoor kitchen, everything has just really fallen into excessive disrepair. Everywhere I looked, there was just junk and garbage and clutter and stuff, and then we'll get to the inside. Okay, so in this particular case, the hot tub heater was damaged in the storm. That's a $4,800 fix.
Wow.
He has gone through, the spouse that's in the house has gone through, done most of the repairs as cash out of pocket, but there's still $30,000 that he says is still kind of lingering there. And you'll see some of the pictures as I go through, but just lingering. And, the money has to come from somewhere. So, as I mentioned, in this particular case, everything has been repaired in the house as far as the walls go. But at one point, up to the light switches, everything had been cut out, okay? The one area that didn't happen in is the kitchen, and kind of wonder,
How is that possible?
how is it possible that they still have lower cabinets and everything from 4 feet down in the kitchen? If there was raw sewage in the house, which is what I was told. And there's kids living in here and they're doing food prep and other things. It doesn't appear to me that any type of mitigation occurred with, like a disaster mitigation. So there's another complexity, right? With having children in a house with something like that you just don't really know what's going on there. And every other house, and I'll get to pictures of homes that have had all of that cut out, and the kitchens have been completely gutted from the lower cabinets down. So, it's kind of, it makes you think, like, why is this kitchen still here? Because really, it should be gutted. I don't think that the kitchen was very nice at some point. I don't believe that they're gonna be able to replace the cabinets and match what's there. So that really means like a full kitchen gut and a total remodel. So, you go from 30,000, he's kind of predicting to fix the few things that are left to maybe, an additional 30, 40, 50,000 for the kitchen if he stays in the house. I didn't ask questions. I wasn't brought in to ask those questions, but, you as mediators, if you have someone that wants to stay in a house and they've had damage like this, it's certainly a question that I would be asking is, well, what about the kitchen?
Yeah, how did the sewage stop?
Right. Did you have the sewage mitigated? Like, why is the kitchen why are the lower cabinets still in this kitchen? Did you have a disaster mitigation company come in and clean them and all of that? My guess is no. In this particular case, my guess is no, based on the condition.
I have a question. Is the rising cost of homeowners insurance affecting resale of homes? Are people thinking about that at all?
So the rising cost of insurance is a real problem. I just put a home under contract, and the house was in absolutely perfect condition. And they had one little issue with the HVAC not having a hard wire shut off. So, to the electrical box. And they said, we absolutely will not, this is a safety issue, we will not insure for this. And so we had to negotiate with the seller to get an electrician out there to hardwire the box, because if they weren't, the buyers, they're not getting insured. This particular house is in a flood zone, and the insurance, the homeowner's insurance, I think, is around 4,000. And the flood is around 6,000.
Oh my gosh.
Okay, so the answer is absolutely, absolutely. If roofs are beyond what the insurance company feels is, they've exceeded their life expectancy, windows, doors, plumbing, HVAC, hot water heaters, all of those things are absolutely factors around the house. Because if one person keeps the house, they may need to resubmit a whole new 4-point inspection, and possibly even a wind mitigation report to the insurer to have that policy underwritten in just their names. So it could be a surprise. I mean, they may find the house is no longer insurable, or if, they are insurable, that they can't afford the insurance. And then something has to happen. So like the loan, everything to do with the house, the sooner you can be on it, mitigating it, reviewing it, digging deep into it, the better the outcome is going to be for everyone in the negotiations down the line. Okay, so I have to really get through this fast, as you can see, just things on the lower level, And there was just stuff everywhere, and this house has been restored, so I walked in, and while, you know, they live one way, everything in the rest of the house has been restored. You've got new carpet, new drywall, new tile, new baseboards, new all of that, okay? So all of that stuff has been done in this particular house. You know, you've got bathrooms where no vanity tops. Again, I'm not sure if that vanity was there, or if it's something that was maybe bought at a Habitat store, so they have something temporary that they could just drop a sink in so their kids can wash their hands and brush their teeth. I do not know. I wasn't hired to ask those questions, okay? So yeah, this is bathroom number 2. We go to the master bathroom. You've got, you know, dual vanities. This particular vanity in the lower left, it was just kind of sitting on top of something, I think, again, just so that it was functional. But, you know, the house was certainly livable, I guess. Without asking too many questions. So what I do is I go in and, you know, I will provide my opinion of value. In this particular case, based on, and they did so much, this was a really, really hard house to comp, okay? And this again is where having someone really truly experienced in valuing homes is going to make such a difference. They purchased this home as a 3-bedroom, 2-bathroom, two-car garage with no pool, okay? It was built as that. It was built as that in 2004, and then it was purchased in 2011 with the same criteria, okay? And then since the house was purchased, they added around 300 square feet, increasing it to 2,750 square feet with a 4th and 5th bathroom, okay? That probably doesn't sound like anything crazy, but I'll get into where it gets a little bit crazy. And then they added a goodnight pool with hot tub and an outdoor kitchen, and those were added in 2022, okay? So where this gets really sticky is that I could not find a comp for 5 bedrooms, okay? Those certainly were not comps in the community that they live in, which is going to be the best source for comps. They have lots of 3 bedrooms, many 4 bedrooms, some with 3 bathrooms. Anything that was a 4-bedroom had a 3rd garage. This was built as a 3-2 with a 2-car garage, and then they added square footage, they added bedrooms. So it just kind of threw monkey wrenches in all of that and trying to establish a true, like a solid, and then you've got damage on top of it, okay? So it got very complicated. Some additional considerations were that the entire community experienced flooding, and that may be a factor of value, and in resale. So not just the resale of, just the value of that home, but the resale of that home, because now that everyone knows that that community had unprecedented flooding, I mean, the property values could absolutely go through the ground there.
Yeah.
And that's reality, and the only way that you really know that is to put the house on the market and see what happens with it. So, again, just a lot of unknowns with where that's gonna go.
I have a question. Are people coming along and lowballing, and people that have money and lowballing to buy properties like this? Thought that they can make money down the line. In other words, they don't care so much about that house. They like the location and, whatever.
So I run into investors,
Investors.
Yeah.
So I have investors, right? I have investors all the time, and as part of the code of ethics as being a CDRE,
Uh-huh.
is that I would not call in my investors on a house like, on a house like this, because they're going to offer pennies on the dollar. And I don't double end either. I don't sell the homes that I list and double end that. I don't bring the buyer to it. It gets referred out, it goes to someone else, because I can serve one master. My goal is to sell that house for the highest amount of money. And if I'm representing buyer, it's my job to get that house for the least amount of money. And I can't do that inherently. There's just a conflict there. So as part of my code of ethics, I don't work both sides of that. But that includes, investors as well. So, but the answer is yes, it's happening. It happens a lot. Whether people have the ability to sell at that lowball price, it's a case by case basis. Okay, so I'm gonna kind of scoot through this because, I wanna get to the value. So in this particular house, if it were to be listed today in as-is condition, so keep in mind, we have a kitchen that we don't know if it has sewage. Parts of it are ripped out. The stove is hooked up to propane, but it's a propane gas stove, but it's not connected, so they're using like a little portable,
Like a camping one?
not a camping one, but it's, you plug it in like a little griddle. They're using a little griddle to prepare food on. It's hard to say. Every other area of the house except the bathrooms is in pretty good condition, it's all been restored, but so if that were to go on the market today in the condition, kitchen aside, right? I think that the recommended list price would be $599, okay? But then I get into things like the kitchen. The kitchen should be gutted and replaced because, as we talked about, I don't think it could be matched. The primary bathroom, gutted and unfinished with 2 vanities in need of replacement. It's missing drywall, glass shower enclosure, the 3rd bathroom. And those are just the things that I saw. And I was in there for about 20 minutes. Normally I do an extensive intake before I ever do a walkthrough of a home. In this particular case, the in-spouse just would not talk to me, would not. And it was just an uphill battle, even to just get me in the house to be able to do the walkthrough. So, I was in and out with no intake. So there are a lot of question marks that I still have, and I can only provide what I know. So,
This
okay.
is an extensive report. I mean, this is
It's
extremely
extensive, it's
Yeah.
extensive, so yes, yeah, and every single one that I do is like this. Because especially in litigated divorces, in mediated, you may or may not need something like this, and I do charge for this.
Right.
And in this particular case, I did multiple valuations. There were 3 different point in time valuations, which is, kind of what we're gonna cover here. I wanna get to it, but there were point in time valuations. So on the little grid that I had given to each of you, date of purchase was not applicable. There was a date of marriage, date of filing, and current comps. So we've got market valuations for each of those with the comps that I use for that particular house. Okay, the last thing that I want to do before I move on from this is just take you down, because this is what I kind of thought the house was going to look like when I went there. And these are all comps that I used to come up with the value that I just mentioned. Okay, so these particular homes were flood damaged. And you can see that this is what I really expected to see when I went into this house, where the bottom half of the drywall was cut out. And you can see the blue cabinets, those are the uppers of the kitchen. This is really what I expected to see. And when I went in and saw that all these lower cabinets were still there, and they're the same as the uppers, and the house was flooded with raw sewage, it just kind of got my brain going a little bit, like, what's really happening here?
Why would they do that? I mean, is it
I mean, because they didn't have flood insurance, so it was coming out of pocket, is that why they would, and figure that they're selling it anyway, and you
So
can't
in this
stain the
particular-
drywall because of the cabinets?
In this particular case, the spouse that is in the house wants to keep the house. He does not want to sell the house.
Oh,
He
he
wants to
wants to
keep the
keep it.
house. Mhm.
Okay, so did they not have flood insurance, these people?
Correct, there was no flood
Okay,
insurance.
so this is all out of pocket for them,
Yes,
gotcha, okay.
but it still raises the question of how safe and sanitary can this house possibly be with these kids living there
Right,
when we don't know what's behind the walls. The walls could be moldy behind the
oh, sure,
cabinets
right
in the
now they
kitchen.
are.
Right, so you've got the question of the raw sewage, but then you also have the question of if every other wall in that house was cut out and replaced, and every carpet, every baseboard, but the kitchen is still intact. What is going on with the walls behind the kitchen
yeah.
cabinets?
Oh.
Like the water didn't just not go to the kitchen, it's in the middle of the house. So, just some questions, that just, anyway. So I don't want to get too deep into that, but this is really an example of what I provide when I do a market valuation, okay? So we will just pop back over to here. And let's see, so we were on the value of the house, so I'll keep going, and I'm gonna kind of really just flip through these, so that we have, so we've got time to get through everything. And so I can be respectful of your time. So we touched on point in time valuations, which is this little thing, and that's got, just the different points in time. That kind of really comes into play frequently when one person owns a house before there was a marriage, and they want different points in time in terms of valuations.
When you're figuring out the premarital and then marital, how much okay,
Yep,
right.
yep, absolutely. Okay, let's see here. So the next thing I want to just touch on is very often appraisals are used. Okay, appraisals are the standard. The courts want them, the judges want them, the attorneys want them. If you look at this particular slide that I've given to you, I've circled number 1 and 5. This falls under their terms and conditions or limiting conditions of the appraiser certificate. The first one is an appraiser will not be responsible for matters of a legal nature that affect either the property being appraised or the title to it. The appraiser assumes that the title is good and marketable and therefore not render any opinions about title. The property is appraised on the basis of it being under responsible ownership. So that's one. The other is the appraiser will not give testimony or appear in court because he or she made an appraisal on the property in question unless specific arrangements to do so have been made beforehand. Okay, I cannot tell you how many times I've testified and the appraisers will not show up because they will not testify. It's not that they're incapable of it. They will not testify to a value in court. That could be for a number of reasons. A lot of times, in my experience, it is because wife hires an appraiser, husband hires an appraiser, and the values are this far apart. And, the one that's higher, right, or lower, the appraiser will not come in and testify because they cannot validate, they just cannot explain it. In this particular case, I had to testify in this one. The appraiser was there. He used comps that were not even in the community. It was a 2-story house and he used ranches, which sometimes you have to, but as a standard, there's no excuse for it. Just because the house was on an acre of land. And there's just no excuse for it. Like there were 4 comps that I was able to find. 1 in the community, 3 outside of the community, within a 2-mile radius. It took some really digging to do, and it was not easy, but I was able to find them and use them and provide that as a as a source of value.
Is there any mechanism where the two appraisers get together and pick a third appraiser?
I suppose if the attorneys agreed on that, or the parties agreed on it, or if it was ordered by the judge or the magistrate, then that could certainly happen. And that may be something that would make sense to ask for. Particularly in mediation, you know, where you're trying to limit the amount of disputes that occur. And if you had two appraisers, it's very possible. The question mark there is, are you gonna get two appraisers that agree on one appraiser? Right?
So it's either gonna be a tiebreaker or it's just gonna be another wrench in the.
Yeah,
Well,
it could
seems to
be.
me, at least from where I came from, that the court would get involved and order them to come up with a third appraiser.
And
Or
in
if you-
theory, that makes perfect sense. In practice, you may not get an appraiser who wants the liability of making a recommendation. Like, it just happens. So the answer is, it could happen, it may not, like, it may or may not. I guess if you have one that's willing to and one that's not, you keep going and going and going and going until you find one that is willing, so that you have two that are willing to make a recommendation for a third appraiser that actually goes in and does the appraisal. So, yeah, complications, I know. Okay, so there is that. Next, we're going to go to equity in the sales and the proceeds distribution. This is another very, very important part of the agreement, because that agreement needs to be in place before the house is sold, especially if there is a dispute over the amounts. If it's not gonna be just, say, for example, a 50-50 split, and there's a dispute over it, the title company will not disperse proceeds without an agreement in place, okay? So they need to know, how am I dispersing these? And there's only so long that they can hold those proceeds for, before they have to, release them, okay? So, when I take a listing, one of the very first questions, even before it goes on the market, is where are you going after this? And what is happening with the sale proceeds? Has there been an agreement made on the sale proceeds? Sometimes there is, sometimes there isn't. Sometimes the answer is, we're working on it, we'll get there, okay? Let's just get the house on the market, we'll get there. Well, that's all fine and good unless you don't get there. And I had one house that didn't get there, and the sale proceeds on that house were around $800,000. And the title company is only able to hold those proceeds for so long. I don't recall what the exact amount is. I want to say it's somewhere in the range of 90 days. And then they have to send them to the state. So it's a big deal. And the title company kept contacting me. I need instructions. Well, I think one of the spouses hadn't paid her attorney, who was the one who agreed to draft the agreement, get it sent into the court. You know, they were each supposed to get a little bit of money, and the rest was supposed to be held in escrow until a certain period of time. None of that happened. And it's, been probably close to a year, and that has just recently been settled. So, this proceeds distribution is a very, very big deal, especially if you have tight monies that the people need the money to be able to
Yeah, but
move on.
is that something that they should be getting into in mediation? As far as asking them about the proceeds, how it's going to be?
So the proceeds distribution should be part of the MSA. Okay,
So that they agree to it then.
Yeah, it is. I mean, that would be the thing. If you're gonna sell the house, you're gonna split it 50, you take all this stuff off the top, you're gonna take this off the top, and now you're gonna
so
split it.
And the title company could use that agreement as the distribution agreement?
in my experience, the answer is yes, they can use it. I'm not an attorney, so I don't want to give it, I want to just
Right.
kind of stop short of that. And you guys are the ones who are writing these agreements every day and working with the parties. but it's a big deal.
Yeah, I just didn't know if the title company would
Mhm.
use that agreement and say, oh, okay, I'll disperse it this way.
Yeah, and the other thing too is when there is a dispute over where the proceeds are going in litigated cases, usually one of the attorneys will say, I'll hold the proceeds in my trust account, okay? And there may be marital debt that comes up after the divorce is finalized that they know is there, but they don't know how much is there. And the attorneys may have, say, for example, a $50,000 holdback to cover any of these unknowns. Where you are mediating, you don't have trust accounts. It's something that you need to have an attorney, a real estate attorney, who can either draft the agreement, okay, like, the escrow agreement that both parties would agree to, and then they would hold the funds in their escrow accounts and be responsible for distributing the funds. So there's just some, some nuances there too. Whether you guys get involved in that much or I don't know, but it is something to.
Well,
take
what
into
we do
consideration.
is lower income, so, it's a combined income of $100,000 or less in our program.
Okay.
But that doesn't mean that they don't have a lot of assets, it's just.
They won't be able to see the screen, but they also share this thing. Okay, I just want to make sure that I can get through this in a lot of time. So next we're going to talk about timing and order of agreements and death and divorce. So here's another one that so often I'm called in to settle divorce and the divorce is already finalized. And then I find out the circumstances around the divorce, and one might be a recovered addict, another may be dying of cancer. Or we may have that in one case, right? If that divorce is final, the minute that divorce is final, it changes things. We go from joint tenants in the entirety to joint tenants in common. And that turns this into, if one of these spouses dies, it turns it into a probate case. Okay, so timing of agreements in the sale of the house is very, very important things. And attorneys are drafting these agreements, like these are things that even attorneys are doing. And I don't believe that it's intentional, I think it's just there happens that they just made a little slip with circumstances or whatever it is, just took so long that it just happened to be that the divorce was finalized and then that was it, they were selling the house. So I wanted to make sure that I covered that, okay? So there are 4 types of ownership if real estate and divorce: sole ownership, joint tenancy, joint tenants with rights of survivorship. That is only available to married people. Or sorry, not that one. There's joint tenants with rights of survivorship and tenants by the entirety. Tenants by the entirety is the only type of title that is available to married people, okay? Beyond that, I've got definitions of what each of these means. I'm not going to go through and read every one of those to you, okay? There is also a handout that I provided with common ways for individuals to hold titles in real estate. Everyone got this. Is something that I would recommend that as you are, if you're mediating, if you need to kind of refer to this, it's a great way to, to be able to get some information and to have it at your fingertips, okay? So I am now on, let's see, slide 29. If you're following along online, I'm on slide 29, okay? That's tenancy in common. That's when two or more individuals who are not married with each other take title to real property. We're gonna go to joint tenancy with right of survivorship. That's slide number 30. Joint tenancy with the right of survivorship provides an alternative option to tenancy in common and is often used among close family members who prefer to keep the ownership interest in the property within the family. Okay, so there are caveats to each of these because again, even if it's not a divorce and one person dies, it is gonna impact. Like you could end up in probate because of the way the title is held. Okay, unless there's some form of agreement or trust or something like that that has been established. Okay. So then we have tenancy by the entirety, and as I mentioned, tenancy by the entirety can only be created between individuals who are married to each other at the time the property is acquired. The next part of this is wills. Okay, I'm not going to get into a lot with wills, but the reason I included this here is because it has a lot to do with real property and beneficiaries, okay?
Second marriages.
So I'm not gonna get into this, it's here, so you've got slides 32, you've got slides 33, 34. You've got slides 35 and 36. For wills, just dedicated to wills, okay? And that covers a lot of information. And then on slide 37, we're now to the house in trust. Okay, and again, I'm not going to go into a lot of detail here. If you're dealing, if you're working with people who are more low income, a trust does cost a fair amount of money to have written. It's a whole estate plan, but some people have legal aid or just something along those lines that they pay a small amount for through each paycheck. And whether they're high asset or low asset, Florida is a probate state. So if they end up buying a home or keeping the home, if they die, they really, really should have their home in a trust. Because if they don't, they have minor children and it goes to probate. Like it just turns into a great big web of complicated stuff that's very lengthy and very expensive. So anytime there's real estate that's involved, my question is always, do you have a trust? And if you don't, I'd like to recommend that you establish a trust. And at a minimum, they should absolutely have a will, and a will should be reviewed at the time the divorce is finalized. Okay. So let's see. So we've got a revocable trust, just different types of trust, revocable trust, irrevocable trust, which an irrevocable trust may give you some protections from divorce. But again, everything can be potentially contested. So, but that, and then there's something else called a domestic asset protection trust. I did not even know that this existed until I started kind of researching different types of trusts that are in Florida.
Mm-hmm.
So I'm not going to get into a lot here, but it is here for you as a resource. Okay. Beneficiaries. So in the state of Florida, well, I'm just going to kind of go here. Some states have an automatic removal of beneficiaries upon divorce. Okay. And many jurisdictions automatically revoke a former spouse as a beneficiary on various accounts upon divorce, meaning you need to actively designate new beneficiaries after the divorce is finalized. Okay, if you have a will or a divorce agreement that stipulates that, say, for example, child support or alimony is to be paid, the alimony usually dies when the person dies, but if there's a lifetime alimony stipulation, and maybe when they're young people, the MSA may indicate that they need to have a life insurance policy that covers enough to
We got it.
insurance policy that covers X amount of dollars in the event of death. So beneficiaries is a big thing, both in high asset divorces and also in low asset divorces as well, okay? Some people, there are even low asset cases where they may be, they may work at the school, they may work for the government, they've got retirement accounts, they've got 403Bs and 401Ks and pension plans. Well, pensions probably are kind of non-existent, railroad pensions. There's just a lot of things. And those beneficiaries, you want to make sure that they're being reviewed and changed so that if the children are now adults, that maybe the children should be named as the beneficiaries or someone else, beneficiary for the benefit of the children, or that the beneficiary is a trust. So it is something that you definitely want to be reviewing and looking through. Okay. So that is slide 40. And I'm just going to keep moving. So we covered really kind of 41, 42. And then I mentioned just briefly probate. Okay. But I'll get into it a little bit more here. I just want to check my time. So I've got a few minutes left here. So probate, does everyone know what probate is? Yeah. Okay. All right. If there's no written will, the probate court will appoint a personal representative to oversee the distribution of the assets. Okay. And so again, if you have a will, you have a trust, you probably have the ability to bypass probate unless something is disputed. You have a beneficiary that maybe shouldn't be a beneficiary, and you're remarried now to somebody else, and your ex-husband or ex-wife is a beneficiary, or it can be disputed. So it's really important to update those. So last we've got, and I've got some other information in here on probate, just ways an attorney can help you through probate and all of that stuff. Okay, or help your clients through probate. But it's just really there as a resource for you, so that at least it gives you kind of, get your thinking caps on and keeps you, just as a resource for if you come across this, to dig a little bit deeper. Okay. So last, I've got nesting as a case study. Okay, and then we'll wrap it up with that. Nesting can be a great thing. It can also really be a complicated thing. Okay, I have had 3 cases that involve nesting, and one was high conflict, one was mid conflict, one was low conflict. So I'm going to really just kind of quickly go through each of those with you. The definition of nesting is an arrangement where children remain in the family home and the parents rotate parenting duties according to an agreed upon schedule. It provides solid structure for your family and safety and consistency for the children. And it involves drafting of a nesting agreement in writing that's tailored to your family and your needs. Okay. There's also additional source here on the bottom through Psychology Today. You could just go out and do a Google search for the article on it. Just to kind of give you the highs and lows. And in this particular case, the third case that I use, it's a low conflict. There were no children involved, but they were elderly people and they did nest, and I'll get to that. But in this particular case, we have a wife that stayed in the house for a week, arriving on Sunday at 10, leaving the next Sunday at 9. The kids were home alone for an hour, and then the husband arrived. The order stated that the other party, not in the home, and this house was on the market to be sold. Okay. The other party could not access the property while the opposing party was nesting in the home, in the marital home where the children are. It obviously presents challenges when trying to sell the house. So the teenage daughter struggled with the entire process, not wanting to move. She acted by refusing to leave the house during showings, especially when the parent that would come into the home was there staying with her. And then the other parent would just drag her out of the house when it wasn't her turn to nest. So I decided not to get the attorneys involved. Okay, I decided instead to get creative and just work with the teenager to not incentivize her for really bad behavior, but just give her something to kind of like me a little bit. And have her want to cooperate with the showings. So I brought her some Starbucks and some other gift cards so that, and I told her, I said, look, we really need to have you leave the home so that when people come in, they feel comfortable walking through the house. And, you have to kind of tidy things up a little bit, keep your room cleaned up, and being able to do that and give that to her. And then it was just like, it worked like a miracle. She just started cooperating and, was far more agreeable to helping to facilitate the showing process where before she was not. Okay. So in this particular case too, the court had ordered that the husband was not allowed to access the property when it was not his time to access it. And the pool pump stopped working. And so we got on the phone, I went over, he gave me instructions on how to kind of restart things. And, so nesting really takes a lot of collaboration between the parties. It's not something that can be done easily, especially in high conflict cases. It can be very expensive if you have to have 3 homes, right? Because that could happen. You could have the marital home, and then each party has an apartment or something that they stay in, or they may stay with family or, whatever the new arrangement might be. So nesting can be a very expensive process if, and not everyone is able to do it. And then 2, it can be very contentious if you have there's a reason people get divorced. If you have one spouse coming into your space and then they're leaving, and when they leave, they've eaten all your food and they leave their messes and everything else behind. And then you come in for 3 or 4 days and you're stuck cleaning up after the person that you didn't want to be married to begin with. So it is something that really, really requires a thoughtful process. It requires real cooperation between the parties. I'm not telling you what to do, but it's something in my, just from my perspective, that it would be reserved for extreme cases where you have a child who is severely disabled, whether they have autism and the shift between places is very disruptive to them, or you have a child that is physically disabled and their house is handicap equipped with either ramps or with the lift, so that they can get back and, they're able to get around and in and out of the house. It is my opinion that it should just be when children are involved for the most extreme cases. But I'm not the one getting divorced, and I'm not the one mediating or litigating the cases. But just having worked with so many families over the years, it's something that it's my opinion that should really be reserved. Mid-grade conflict. So we've got 2 kids living in the house. Husband was a firefighter who lived at the fire station a few days a week. When he was off duty, he stayed at the house. Wife rented a room. When he was at the fire station, she stayed at the house. They agreed to this, but nothing as formal as case number 1. A challenge in this case was the schedules were sporadic. It was hard to keep track of who was in and out of the house, who was approving showings, who was making the house show ready, and who was there for inspections and such. So nesting can sometimes also escalate to conflict if one spouse feels that the other isn't pulling their own weight to get the house ready to sell. And then the third, which was a low conflict, we've got an attorney who referred the case, and wife was represented, husband was pro se. They both lived in the property full time. They didn't have children. They were in their mid to late 70s. And so I communicate separately but equally between the parties. I performed the listing agreement, the listing appointment. First one was on Zoom with the husband. The next one was with the wife. And she on Zoom, she's like, husband says, hey, Amanda, so they're fine. They're living together. They're amicable. They were both respectful of me, and the communication that I had with both of them. Okay. So things got a little bit dicey when the house went on the market. The wife leaves the country to visit her ill mother in Japan. They got 19 offers in 4 days for just over the list price. They ended up accepting an all cash offer so that they could close in 10 days at the end of the year. the wife's side of the country and not given a POA to anyone. So POA can also be something that's a little bit on the dicey side. In a divorce, it could be considered a conflict of interest. I would say it's a conflict of interest because I've had this happen so many times where you've got one spouse that may be in a drug or rehabilitation. They may be incarcerated and they cannot sign. Should the wife be given POA to sign on behalf? It's my opinion, no, but I'm not a lawyer. Okay, so as you're navigating that is something again to just think about so that you've got some layers in place for whatever it is that you may have to have the court sign off on it. They may have to assign an excelsior to sign on behalf. Or the spouse that is incapacitated may, if they're have the mental capacity, if they're drug addicted and living on the streets and you can't find them, you can't get them to sign a POA. So there's a lot of things around, and that's the reason why I included this low conflict in here was specifically around the POA. And how that can just add complexity to something that otherwise seems kind of really like, oh, so we got a POA and everybody signed and it was great and happy. And that's wonderful when it goes that easy. But sometimes a POA is not even, it's not practical, it's not possible. And it may not be ethical, might not be legal, like it may not literally even be held up. So if the spouse that say, for example, if the spouse is in drug rehab and they signed a POA to allow the spouse that, you know, the divorcing spouse to sign on their behalf. And then they get out and they say, wait a minute, I was in rehab. I wasn't in the right frame of mind. I really didn't want to sell my house. There could be some things that come back because of homestead. So it can really add some complication there when you've got people that are maybe not in a clear frame of mind and you're working with situations like that. So I will leave it with that.
Okay, well, let's, Josh, can we turn it over to our Zoomers? I'm praying we didn't lose. the
I hope not
recording
too,
For
yeah.
that small period of time you might have, but it's still recording. All right, well, Josh, you wanna see if you have this question?
Is there anybody out there who would like to ask a question or two? We've got,
We started a little late.
Yeah.
And I'm happy to stay as long as anyone has questions. And I apologize because I know we're a few minutes over, but
not seeing anybody in the chat or otherwise.
Okay, we did have one question that was sent to us.
yes,
for you.
Yeah, I sent it to you.
I do have that. And it had to do with, I believe, division of equity. Bear with me 1 second, I will find it. So the question that came in was from Jill St. Louis, and the question is, many times divorcing couples own a home. Due to an increase in home values in Florida, they often have significant equity in the house and a low interest rate mortgage. Any suggestions and alternatives to selling the home and splitting the equity? Often these couples can't afford to purchase another home with the high cost and interest rates. And they usually do not have the funds for one party to buy the other party out of the other half of the equity. So I did cover a lot of this when we went through the mortgage, the different types of, the different terms around mortgages, the assumptions. We talked about the St. Germain Act. So the average equity in the United States right now, according to NAR, the National Association of Realtors, average home equity is $298,000. Okay. That's a lot of money. It's a lot of money. And so being able to get that out of the house and, you know, whether it's through sale or whether it's through cash out refinance or whether it's via some other method of determining equitable distribution of assets that make that fair and equitable, right? It's a lot of money. So, you know, I guess, and I know that I hope that I answered the question. I don't know if we have, Jill, are you on the call still?
Oh, yes.
Okay. Did I answer your
Yes.
question for you?
Yes, well, some of the other, like the checking in to see if they could do a qualified assumption, things like that, that I was not aware of. So those are all good ideas.
And just as an additional topic, since we're talking about this, under the qualified assumption, there is actually a letter, and I can get that over to Josh or to Michelle or to Lynn to send out to all of you. I don't know if it works or not, but when I was doing the research on this, there's a letter that you can actually draft and attach a copy of your MSA, or not your MSA, but the parties can attach a copy of the MSA outlining what they want to do, namely a qualified assumption. And the lenders are supposed to abide by this when it is spelled out exactly in such a format. So I will get that over to you so that you can just kind of send that out, so that there's a guideline for it that you can at least share with your clients if it happens to come up.
And what are your, so even sitting in a mediation conference, I mean, you suggest picking up the phone and calling these
Yes, I do.
lenders, because if you don't do it and you put anything in writing where you're actually using actual figures, 9 times out of 10, it's not going to be those figures. So is it better to get somebody on the phone, try to get some real solid figures, or if we can't, at least talk in generalities such as like percentages, like whatever the house sells for, husband gets 60%, wife gets 40%, or 50-50, something like that, instead of actually, trying to say the parties agree to sell the house for the listing price of $700,000. They have $295,000 in equity or outstanding loan. Instead of using those exact figures, just try to be a little bit more.
Just more general in nature, yes. But I would absolutely encourage each of you to, and I can send the name of a couple CDLPs. We have at least 3 in this area. I know 2 of them very well, and one is bilingual. So I would encourage each of you to just reach out to them, schedule just kind of a discovery call with them, an introduction call, let them know that you're mediators, that you're doing divorce frequently, and just let them know, you may be calling them out of the blue to ask them for different scenarios, and are they okay with that? I have never had one problem. I personally do it all the time. Because if I have clients who are, well, I'm on the fence. I think I might want to keep the house, but I don't know this or that. Or when I'm structuring an offer for a purchase for a home, they may not even be divorce related. I still use the same divorce lender that I use. I still use the same lender for everything. Because they're so knowledgeable, and it just divorce and with structuring, and they just have creative ways that just traditional lenders, in my experience, they just don't have. And so I would absolutely encourage each of you, have 1, have 2, have 3 that you can just reach out to at any time, and run a scenario by them. So, yeah, definitely.
Okay.
Thank you so much.
Yeah.
That particularly is very helpful.
Yeah, you're very welcome. Were there any questions?
The only other question that I would have is, in a divorce, do you have couples try to change the deed to joint tenants, not by the entireties, but like joint right of survivorship and include minor children?
I personally do not, but I am not involved behind the scenes like you are, having those types of conversations. Just kind of off topic on that, just as a personal experience, I lost my father in 2015, and he owned a house in Scottsdale, Arizona. And I have a half brother who had just turned 18. And my father wanted that house to go to my half brother because it was the home that he had been raised in. And prior to his passing, he quitclaim deeded the house so that my brother was the sole owner of the home, so that when he died, he did not have to go through probate. And the mortgage is still my father's name. And eventually my brother had to sell it because there was a sale on demand clause. And when the mortgage company caught up, my brother either had to refinance to put the mortgage in his name or the house had to be sold. And he ultimately ended up having to sell the house. At least it was his to sell without having to go through probate to prove that it was his to sell, because otherwise it really would have gone to myself, my brother, and him. And he was young. We just, my brother and I have our full lives, and we didn't want to interfere with that. But if there were multiple kids, you can really do anything you want to do. And I'm not giving legal advice, anything can be done as long as you have the agreement of the parties to do it. But it can make complications too.
So just to revisit something you said earlier, I don't know if I misunderstood you, but say in the agreement, in the mediation, in the agreement, the husband says the wife can have the house, and that's written in the agreement. You said that because the husband's on the mortgage, that the lender can still come after the husband if she defaults on the house? Is that what you said or no?
Yes.
Oh, it is, okay.
So basically, it's kind of like credit cards, just because your husband is, if it's a joint credit,
Okay.
credit card, for example, just because the husband agrees to take, over the payment of that credit card, that's just between the agreement of the husband and the
Right.
wife. Bank of America or
They don't.
MasterCard
Yeah,
doesn't
they don't
care what your agreement
They
is.
want their money.
You both are on the hook. Then it's a
Correct.
civil issue.
Correct.
It becomes a civil
But
issue.
that's one of those things, right? That if you were if that was being negotiated, that debt, and I'm not giving legal advice, it's really just from experience, working with litigated divorces. If one of those spouses agrees to take that debt and it's a joint marital debt, it's in both of their names, that debt is paid off at the time of the closing of the house. And by closing of the house, I mean, whether it's sold or whether it's refinanced, okay? If it's sold, the title company is writing checks to everybody. They're writing checks to the lender, they're writing checks to me, they're writing checks to for the HELOC, they're writing checks for taxes and HOAs, but they also may be writing checks if it's stipulated in the MSA, or if it's written in the MSA that these debts are going to be paid off by the title company from the proceeds from the sale of the home. That title company is required to write those checks because they have to convey clear title. They are hired by the buyer and the lender for the buyer to convey clear title. And it is their job to convey that clear title.
But who sets the priority then if there isn't enough money?
Well, that's why you have a payoff, and you know what the payoff is, so that when you're
But if your house isn't
negotiating,
sold yet, you don't know.
you do
That's what I
not
mean,
know.
if in the agreement, the husband just says, yes, there's kids, the wife can have the house, but they don't do a quick claim deed or any kind of legal deeding the title, or it's not even just the title, because he's on the finance. Say in 5 years, she stops paying the mortgage, loses her job, stops paying the mortgage, now he's on the hook as a default on the mortgage, because he was on the original finance, right?
Yeah, if he's on the
If
loan,
he's on the loan, right, okay.
Well, he wants to get his name off. So like in my divorce, I refinanced and that was part of the deal with my
Mhm.
ex-husband was like, you could get me off of here. Because then it did hinder his ability to even rent a place because he, so.
Because it was showing he had a mortgage.
Yeah, right,
Income to
exactly.
debt ratio.
right, and in a case like that, your debt to income ratios are one thing, and it's showing up as that, and you don't qualify under this qualified assumption when you're renting something, so they're not excluding that. If you have an MSA that states, blah, 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 whatever it is, whoever you're leasing from may or may not take that into account, but it's,
Yeah, it's sticky.
it gets sticky. It's sticky, kind of like nesting. I have certain opinions about when houses are not sold at the point of divorce too. And I just, in the interest of time, I won't get into them. But, you know, it can get really, really sticky if the house falls into disrepair and there's a certain amount of money that's been agreed to the other spouse on the point, you know, at the time of sale. And then there's, you know, you don't have, the house falls into repair or a hurricane hits it, or it gets burnt by a fire or a flood and
The market drops.
whatever, right? Any of those factors. I mean, everything we've seen in the last 6 months has happened.
Yeah.
Just natural disasters. Yeah, all of those things. Any of them, all of them can happen.
Right, right.
We've got a question
Sure.
here. Don, do you wanna come off of mute and address your question?
All right, actually, question or comment, you know, when talking about credit reporting and stuff like that, one issue that I haven't heard, they're not joined on the account, but they're a card holder. So you have the husband gets a credit card, and of course, he's got his wife with a card. That will show up on her credit that she's a card holder. And one of the things when people get divorced is to recognize that those type of things, they need to write to the credit bureaus to have removed, or to the credit card companies to have them removed as an authorized signer, so that the debt from that does not appear on their credit report. And it depends on what kind of credit you're trying to get, but it does show up on your credit report until it's removed.
Yes, was that a question?
It was more of a comment.
Yeah, more of a statement.
More of a statement.
More of a comment, yeah. I mean, basically, hadn't heard that brought up as far as people with their credit, you know, where they're an authorized signer on it. And it's,
Yeah, and I agree with that. Mhm.
How often, and I know everybody's gotta go, and if anybody does need to go, you know, feel free, but just one last quick question, at least for me. How often would you say you have people who are very emotionally tied to their home? I mean, they're divorcing, it's, you know, this is where their children were raised. A lot of times when you love something, when you're in an emotional state, you think it's a lot more valuable than it is. So in your experience, how often do you get a lot of arguing from, you know, divorcing parties about your assessment, and what do you do when you have that situation?
So that's kind of, there are multiple answers to that question. So it could be ultimately the sale of the house is dictating what the value of that home is. Okay, so if someone thinks the house is worth $1 million and we have it on for 90 days and we haven't had one showing, guess what? It is not worth $1 million to a buyer. They don't even have enough, they don't even see enough value from the listing to come and see it, let alone to make an offer on it. So at that time, you know, and before that, I would be performing revaluations to address where the market is, what is happening in the market, and making recommendations on price reductions. And if we reach an impasse, if it is a litigated divorce, I would involve the attorneys in that to either, you know, so that the one party who is not being realistic can either be talked to by their attorney. If I cannot do it, I use the attorneys as the last resort. Where they can talk some sense into their clients about the practicality of, you know, of a price reduction to a more reasonable number. Because the longer the house sits on the market, the less it will sell for. That is a proven fact. Okay, when it is priced right, it sells within the market time. So if that's 5 days, if it's 5 minutes, if it's 30 days, if it's 45 days, and I think the average right now is around 71 days.
And your CMA would reflect that.
Yes,
The price.
so, correct. So, you know, if I know that when we put it on, it was priced pretty correctly, but, you know, we're at 45 days with no showings, and that is a long time to go with no showings. Like, say I have open houses, and if I have people come, I provide feedback. Oh, we had 5 tire kickers today, and we have one neighbor that came, and he did a video walkthrough with his friends who's moving from New York, or whatever the case is, you know? Ultimately, if you are not getting in-person showings, they are the people who are qualified. they're coming with their lender. They want to see that house because they are interested in buying that house. They're not just coming because it's open and they don't have anything better to do on a Sunday than to go look at people, how people decorate their homes. Okay, so if we don't have in-person showings and it's a specific amount of time, I'm keeping them. We have point in time, just kind of check-ins where I say, okay, this is what's happening with the market. I just want to let you know. You know, I think that we're probably okay, but maybe, you know, if things don't start moving, we should be considering a price reduction in the next 7 days, or I'll have another open house. And if we don't get an offer, then we need to consider a price reduction. So, you know, there's that factor, and then there's a refinance where you have one spouse that wants to buy the other out. And yes, the answer is yes. People are very attached to their homes, especially if they've raised their children in them. And I have found that there are a number of things that happen. Some people just cannot see themselves, that the house is often a status. And they do not want to leave that house because they're so afraid of losing the status that goes with the home, or living in the neighborhood, or whatever it is that came from that house. Is it wrong? No, it's not wrong, but it can be a hindrance, and, you know, it affects the motivation of the person to sell, especially if they're the ones living in the house. It can make it very difficult. They can sales sabotage. They can sabotage showings. I have had experiences where something like this happened, and the seller was out when the neighbors were all having open houses, and they were giving when the house was being showed to private showings, and handing out houses that were nicer than hers were. That were lower priced. You should be looking at this house. You should buy this house. This house is nicer. It's less expensive. It has more features. So it happens.
Were they getting a cut from that sale?
It happens. It happens. But you know, and that's the thing. Or, you know, people come and they come to see the house, and you've got neighbors that you need blast music, or the neighbor. It's just, we're dealing with people.
Right.
And there's emotion that goes with it. So, I mean, every scenario that you could possibly think of, I'm sure has happened at some point in time somewhere. But yes.
Well, thank you. Thank you very much.
Thank you
My
so much,
pleasure.
Amanda.
Thank you. Thank
Very interesting.
All right, well, she's still gonna hang tight for a second. If anybody that's still on the call has any other personal questions, she'll stick around, but otherwise, thank you all for coming. I'm gonna get the recording. I hope the recorded everything, but I think we might have lost, that little period of time when we, went offline. But anyway, thank you all for coming. I really appreciate it.
So much.
All right, and if you have any other real estate questions that are more directed towards something very specific that she talked about, that she kind of said she flew through, like the wills part or anything like that, she's willing to come back to do a smaller, shorter, more in-depth continuing education for anything that you heard today that might be worth getting a little bit more involved in. Okay.
And like I mentioned, you know, having a lender on just kind of speed dial. If you ever have questions that come up, give me a call. Give me a call or shoot me an email. Even if you're in a mediation, do not hesitate to call me. I try to always answer my phone, but if I don't answer my phone, it's because I'm doing something like this, or I'm in meetings and such. But I will definitely call you back, or you can text me. Texting is a great, hey Amanda, I was on the training for the 12th Circuit. I'm in a mediation. Can you provide some clarification on da.
Okay.
So I'm
Well,
happy
wonderful.
to.
Well, we will go ahead and send out, if it's okay, I will send all the materials. I know we sent the materials to the folks that RSVP, but we'll send all the materials to all of our volunteers as well with your contact information. And, thank you.
Thank you so much.
My pleasure.
Stay, see you.
You sure you don't want to cookie before you go?
That's all right.
All right, thank you. Okay, bye-bye, everybody.